Hello, welcome back to Article 1, recognition of contract bargaining agreement between the union and the administration of the Commonwealth of Massachusetts. In recognition, basically it sets forth who is recognized. The union is recognized as the exclusive bargaining agent. We meet with the administration and forge agreements or problem solve for the most part. It also specifies that only HRD, or the Human Resource Department, has the authority to make agreements and commitments with the union. So, for folks who have an inclination to try to take things into their own hands and forge agreements with their own individual administrators, the system isn't set up that way. And what you need to understand is that any agreement that might have been forged is not enforceable by law or by the contract. So it behooves you to work with the union to make sure that you're negotiating something that will stand the test of law and time. Employees are defined in this contract bargain, in this article, as full-time or part-time employees. There are exclusions, and those exclusions are managers, confidential employees, short-term federal positions filled with people from the Commonwealth, and intermittent employees, basically working vacation times during the summer, that sort of thing, and 03 and 07 consultants or contractors. And these are, the 03s are the private independents. The 07s are people who are working for a placement agency. So recognition sets forth who are the players in the negotiating process or the labor management process. And David, let me ask you from a manager's perspective, administrator's perspective, what's going on here?
Okay, to flip it a little bit, the recognition clause is who we are and why NAGE exists. That's to be recognized by management that the union is the exclusive representative on behalf of employees in its bargaining unit. If you're in a Unit 6 title and you're full-time or a regular part-time employee, you're in the bargaining unit and you are represented by NAGE. You are not alone but have the full force of the union behind you. NAGE represents you in negotiations with the employer on terms and conditions of employment, and that is your collective bargaining agreement. And also the union enforces your rights under the contract. There are exclusions to this bargaining unit status. One, managerial and confidential employees. Over the years, management has stretched this exclusion beyond its proper definition. Chapter 150E, the state collective bargaining law, defines a managerial employee as one who participates in collective bargaining or who hears grievances at step 2 and above with the authority to adjust those grievances, or who participates to a substantial degree in the formulation of departmental policy. This is a narrow definition which the Commonwealth has greatly expanded with managers who are not really managers. In the most extreme cases, a so-called manager may be supervised by a bargaining unit employee. That's how little of a manager they actually are. Confidential employees are defined as those employees who directly assist true managers in a confidential capacity. NAGE has been working to correct the abuse of this exclusion over time. The second exclusion is employees who are employed in short-term federal or state programs. The most recent example of this were short-term positions established by the American Reinvestment and Recovery Act. In these cases, the bargaining unit should be supplemented, not supplanted by these jobs. That is, no bargaining unit employee should be replaced by these positions. The third exclusion is intermittent employees. These are employees who do not work a regular schedule or who work less than a regular part-time employee. They're not really regular full-time or regular part-time employees. The fourth exclusion is so-called 03 and 07 employees. These are supposed to be employees with special skills for a particular project. They have, over the years, become longer-term employees who are actually part of the workforce. And NAGE has taken steps to convert these long-term consultant-type positions into regular state employees, once again protecting the bargaining unit. And just to mention it, it is a violation of state law for a consultant to supervise a bargaining unit employee. So these consultants have a very limited role in terms of special skills and special projects. Where that is violated, then the employee should be converted into a regular employee and become a member of the bargaining unit. It bears noting that the exclusive bargaining agent for the Commonwealth is the Human Resources Division when dealing with NAGE. And just to amplify what Greg had said earlier, although settlement agreements are permissible and for the most part an amicable means of resolving disputes, beware of any local manager who tries to amend or modify the terms and conditions of employment as set forth in the collective bargaining agreement. Managers do not have that authority. I would also caution you not to cross bargaining unit lines. If you represent Unit 6, do not meddle in Unit 1 or Unit 3 affairs.
Thank you, David. And from a legal perspective, Richard, with recognition?
Sure. There are a couple of things I'd just like to add to what David had to say. As he did with the preamble issue, he really covered the waterfront very well on with regard to recognition. One thing he said is absolutely true, which is that the Commonwealth has stretched the definition of managers to an unbelievable degree, and we are working right now in the fall of 2014 to get employees who've been improperly classified as managers into the bargaining unit where they really belong, because they aren't really policy makers. They don't really have the authority to adjust grievances at the step 2 level or above, and they don't have anything to do with the formulation of collective bargaining proposals, and we are working on that. We also see some of the same issue with confidential employees who aren't really confidential, although that is much less of an issue simply because there aren't that many confidential employees. The other thing that's important to stress is that with respect to the recognition clause, the recognition clause is really based on a determination of which employees are included within statewide bargaining unit 6. This determination was made many years ago by the Department of Labor Relations and includes a very specific list of titles which are considered to be professional administrative. They include titles such as, but not limited to, attorneys, accountants, economists, program coordinators, administrative assistants, titles like that. There are other statewide bargaining units that cover other job titles very specifically. So for example, if you're a steward in the workplace and a nurse comes up to you and says, I need some help, well, that nurse is not in the Unit 6 bargaining unit because he or she is included in another statewide bargaining unit, and the issues of a nurse employed as a nurse in a bargaining unit title should be handled by his or her union representative. And as David pointed out, it's important not to cross unit lines, but it goes beyond just units 1 and 3, which are also represented by NAGE. It also encompasses nurses and engineers and scientific employees whom NAGE does not represent, has no authority to represent, but who are represented by other state unions. Thank you.
Thank you, Richard. And this gives you a good idea of how we rely upon each other for gathering facts and looking at what's going on. And I encourage you to, again, contact your either executive board member that you're aware of, or myself, or David, or Jack Snow, for running situations by us and getting some information, just getting more perspective on each of the articles.